Welcome to the Nevada Commission on Ethics training video on penalties. The three major functions of the Ethics Commission include education and outreach about Nevada's ethics law, providing advisory opinions to public officers and employees, and receiving and processing complaints alleging ethics violations, violations of Nevada's ethics law. And so the Commission's first priority is always to provide education and outreach. But when we do have a complaint process that works all the way through, at the end, the law does allow for some penalties to be imposed against somebody who has violated the law to ensure we have accountability among our public officers and employees. Before we get into some of the key penalties, I want to talk a little bit about letters of instruction and caution. In an effort to allow for education and awareness of the ethics law, the Nevada ethics law has these things called letters of instruction and letters of caution. And they're a little bit different, that they can be issued even in cases where we have a complaint but we decide there's no violation. They can also be issued in cases where there are violations. So as we go further into the video when we talk about remedies, just keep in mind that we can always issue letters of instruction and caution. They're a little bit different. A letter of instruction is really to advise a public officer or employee that there's an ethics law issue involved, perhaps with their conduct. And then a letter of caution is really to warn them that their conduct, as alleged, was sufficient to implicate the ethics law. In my mind, when you think about a letter of instruction, think about, we see a situation, they didn't violate the ethics law, their conduct wasn't contrary to the law, but we observed through our investigation and through the allegations that some additional awareness of the ethics law and how it might apply to their situation is helpful. A letter of caution is really when we see something where their conduct did violate the ethics law, or it was contrary to the ethics law, or they got really close to violating the ethics law. And so those allegations were enough to implicate the ethics law, but we're not going forward with a formal case. So just keep that in mind. We have these letters of instruction and caution that the Commission utilizes primarily in an effort to make sure there's education and awareness before some more substantial penalties may be imposed. So when the Ethics Commission takes a look at a complaint case, towards the end, there's some three really key questions that the Commission has to ask itself. First, is there a violation, right? Whether it's a stipulation or it's an adjudicatory hearing, they're making a determination, did this conduct violate the law? If the answer to that question is yes, then the Commission has to determine, is that violation what we call under our law willful or non-willful? And there's a definition of willful under the law, and then it's based on several factors we'll go over in a bit. And then what should the penalty be, right? If there is a violation, we've determined it's willful or non-willful, what should the penalty be? What types of remedies should the Commission employ that will be appropriate to have accountability for the past conduct and hopefully prevent future conduct as well? So as we go through the process, again, did the conduct violate the law? If the answer is no, then the case ends. Of course, as we talked about, the Commission can always issue a letter of caution or a letter of instruction, but there is no violation and the case will just simply end. If the conduct did violate the law, then the Commission has to determine, is it a willful violation or a non-willful violation? And the statute in law gives the Commission several factors to determine. There has to be some intent, right? The person had to intend to violate the ethics law with their conduct. They can't say that they were completely ignorant of the ethics law, but if they have some intent of their conduct and that conduct violated the ethics law, then there'll be willfulness. The statute also sets up these other factors for the Commission to determine, which can include the seriousness of the violation, right? What was the nature of this ethics violation? Did that person have a previous history of warnings or letters or ethics cases, or is this kind of somebody who continually has an issue with the ethics law? If so, it's going to lean more towards willful. The cost of the investigation and the process, if that is a very high cost, that can lean towards determining willfulness. If the individual has done any mitigation, maybe their conduct violated the ethics law and then they realized it, and so they put some things in place so that wouldn't happen again, but in the meantime somebody has filed a complaint, that would tend to make us think, hey, this person is taking the ethics law seriously. That leans more towards non-willfulness. Have they already paid restitution? Maybe part of the ethics violation was taking money from their agency, and so they've already paid restitution. That would certainly go towards non-willfulness. Although if the financial gain is large or substantial, then that will lean more towards willfulness. And then any other matter justice may require. And so that is kind of a catch-all so that the commission can take a look at each case individually and make a determination individually about whether the violation is willful or non-willful. So again, that first step is to determine if there's a violation or not. The second is to determine whether that violation is willful or not. And then there's the examples of some penalties. So the law establishes some different penalties for non-willful and willful. So if it's only a non-willful violation, the Ethics Commission can mandate training for the public official. They can mandate an apology. They can deliver an admonishment. If the person received financial benefits, they can fine that person for the financial benefit and double it to make sure that the agency that they're not personally benefiting from their unethical conduct. And they can also condition future conduct. They may put some conditions on the individual's future conduct. And there's a catch-all that says anything else that's reasonable to prevent a violation in the future. If it's a willful violation, first of all, they can do anything that's in that non-willful column. But in addition, there are civil penalties for up to $5,000, $10,000, and $25,000 for each violation. And so for each separate violation, for your first, second, or third separate violation, it could be $5,000, $10,000, and $25,000. And then there's some specific provisions in there for willful violations where if a public officer, not a public employee, but a public officer, gets to the point of having 2 or more willful violations, there's a process where the petition is filed in the district court where that public officer is to have them removed from office. If it's a legislative officer or a constitutional officer, then a referral is made to the legislature for their evaluation. In addition, on the non-willful side, you see an admonishment. The commission under the willful side can also issue a reprimand or a censure, depending on the seriousness of the violation. So these are basically the tools in the commission's toolbox: training, mandated apologies, formal disapproval. If there's some personal financial gain, then it doesn't matter if it's willful or non-willful. The commission can order that money to be paid and double it. If it's a willful, then there can be these additional flat civil penalties. What's not in the ethics law? A lot of times folks will contact us and they want us to go do something, and maybe there's a remedy that is not within the actual power of the commission to take action. So there's no terms of imprisonment or criminal sanctions. The Ethics Commission can't send anyone to ethics jail or anything like that. Sometimes an unethical conduct can also be criminal conduct, and so if you're prosecuted in the criminal justice system, then you may then the individual may be looking at those types of criminal sanctions, but the Ethics Commission itself cannot impose any criminal sanctions such as jail time or imprisonment. We can't prevent a future violation. So sometimes folks will reach out to us and say, hey, can you please go stop this local city council or this county commission from taking a vote next week? I think it's going to be against the ethics law. We have no power to file an injunction to stop a government action. Also, we don't have the power to undo a government action. If you believe the ethics law is violated and that public body made a decision, we don't have the power to go in and second guess or redo that government's action. So those are some examples of what is not within the power of the Ethics Commission in terms of remedies when they do find a violation has occurred. That concludes the training on remedies. You can follow us on Twitter and LinkedIn for additional educational information. And of course, as always, you can visit our website at ethics.nv.gov. Thank you for taking the time to learn more about the Nevada ethics law.